Doctor.
It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda vs. retired Colonel Dr. Kiza Besigye, Supra. That proof of exceptional circumstances is an application. That proof of exceptional circumstances in an application for bail is not mandatory. In this application for bail, however, the first and second applicants rely on the advanced age as their exceptional circumstances. Section 16, subsection 3, Part C of the TIA provides that exceptional circumstances include the infancy or advanced age. There's no doubt that the applicants are 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, subsection 3, Part C of the TIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Buganda Road Court. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Buganda Road. By interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail, and it has not been proved that before he had deliberately or for no justifiable reason failed to abide by bail terms. Gravity of the offense, nature of the offense, and possibility of trial. Counsel for the applicant cited the case of Makoha Samuel and 35 others versus Uganda, where the applicants were granted bail while being charged with terrorism, contrary to Section 6, subsection 1B, and Section 2 and subsection 2, Part B of the Anti-Terrorism Act. It was submitted for the respondent that the applicants in this case of Makoha Samuel and 35 others versus Uganda Supra are charged with terrorism, which attracts life imprisonment on conviction, while the applicants in the present case are charged with treason, which attracts a sentence of death upon conviction. I am persuaded that on the scale of gravity, the charges against the applicants in this case attract the ultimate penalty and therefore are graver than the charges against the applicants in the case of Makoha Samuel and 35 others versus Uganda. While the charges in both cases are grave, the charges in the present case, in the present application, are more serious. Counsel for the applicants stated that the International Crimes Division of the High Court held in granting the applicants bail in the Makoha case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, basing on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In the Uganda DPP versus Colonel retired Dr. Kiza Besigye, Constitutional Reference number 20 of 2005, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant submitted that no evidence has been adduced in support of the averment that the offense impacts on the national security of Uganda. It was added that the investigators have placed nothing before this court to suggest that there is evidence of any nature at all of to suggest that what they aver. In their response to this point, counsel for the response submitted that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation, and it was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. Counsel for the applicant cited Panju versus Ara, 1973 South African Law Reports at page 282, where it was held that allegations of interference with the witnesses must be substantiated, that such substantiation is not difficult to show. In reply, counsel for the respondent submitted that the first applicant is a prominent and influential person, and the second applicant is his personal assistant, that in releasing them on bail, will accord them the opportunity to interfere with witnesses and investigations which are still ongoing. Counsel for the respondent, on the case of Okello Augustine versus Uganda, application number 6 of 2012, where the court emphasized that once the likelihood of abscondment and interference with investigations have been established, the court should be hesitant to grant bail. In this case, the respondent states that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to state in detail how the applicants are likely to interfere with the investigations which are ongoing, the particular circumstances of the case against the applicants must be borne in mind. The offenses are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere, with the likelihood to interfere with the investigations which are still ongoing. Decision. The main considerations for bail, the main consideration for release of an accused person on bail are the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty except in execution of the sentence or order of a court, whether established for Uganda or another country, or of an international court or tribunal in respect of a criminal offense of which that person has been convicted, or of an order of court punishing the person for contempt of court. Article 28, 3A of the Constitution provides every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Article 23, 6A of the Constitution, in recognition of the fact that liberty may be curtailed even where a sentence or order of the court is pending, provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Article 23(6) of the Constitution entitles a accused person to apply to court to be released on bail. It is clear from Article 23(6)(a) of the Constitution that accused persons, in respect of the gravity of the offense, are entitled to apply to be released on bail. However, the discretion remains with the court to grant or reject the application for bail. See Uganda versus Kano, retired Dr. Kiza, Besigye, Constitutional Reference number 20 of 2005. Among the considerations for exercise of this discretion is the gravity of the offense. Courts will more readily grant bail or for less serious offenses than the serious offenses. The offenses with which the applicants are charged are among the gravest, if not the gravest, offenses of our statute books. In all cases where applicants are charged with capital offenses, the court must always have in its mind the overarching consideration of the gravity of the accusation against the applicants and the sentence that it attracts. As stated in the case of Uganda, Supra, while acknowledging the release of one accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The circumstances of the present case are that it is alleged that the offenses were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offenses are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in respect of offenses alleged to be committed only in Uganda. It was urged for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigations will conclude, to facilitate the committing of the applicants for trial to the High Court. Counsel for that, there will be, therefore, this substantial delay in commencing the trial. Article 23(6)(c) of the Constitution provides that where a person is arrested in respect of a criminal offense, trial only by the High Court, such a person shall be released on bail on such conditions as the court considers reasonable. If the person has been remanded in custody for 180 days before the case is committed to the High Court, I am of the opinion that this provision takes into account circumstances like the circumstances of this case, where one reason or another, investigation cannot be concluded speedily, and provides a cap on the time on remand without committal beyond which time the accused person shall be mandatorily released on bail. To safeguard against the right of the accused person to liberty being indefinitely curtailed. Where the applicants for bail have not yet clocked mandatory bail, bail is a matter of court's discretion, as provided under Article 23(6)(a). In this case, the applicants have, among other factors, proved they have a fixed place of abode, have substantial sureties, are of advanced stage, and are of first-time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, when granted bail, the applicant did not abide by the bail conditions. While the first applicant has charges pending against him at Buganda Road Court, for which he was released on bail, the second applicant has no charges pending against him. As cited in John Muhanguzi Kashaka versus Uganda, Supreme Court miscellaneous application number 18 of 2023, all factors to a bail applicant's credit, including being a first offender, being advanced age, having a fixed place of abode, recede to the background when weighed against the seriousness of the offense. In Young Zeng John versus Uganda, Court of Appeal of Uganda, miscellaneous application number 99 of 2013, it was stated that the granting of bail by court one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail and reaches a decision based on the rules of reason, justice, and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial sureties, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. 1, the charges against the applicants are among the gravest, if not the gravest, on our statute books. The offenses are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offenses alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigations. Signed, Rosette Comfort Kania, Judge, 11th April 2025. We shall overcome. We shall overcome someday. In my heart, I do believe we shall overcome someday. What's the appearance like this morning in this matter?
This is Your Worship. My name is Ernest Kalibala. The team that represents the applicants is led by Grandfriend Elias Owago and Samuel Muizi Bindwa, Aaron Kiza,
Mawe? Cyrus?
Mr. Sekanda Abubeka, Mr. Chifu Michael, Mr. Bayan Nawe, Mr. Isaac Bakala, and Mr. Julius Sekanda. The respondent is represented by Mr. Richard Ilimuka, Chief State Attorney. That is true.
Richard?
Ilimuka, Chief State Attorney. The matter was fixed for ruling and received same.
Well, the ruling is ready. And I have instruction to pronounce the same. Mr. Application number 113 of 2025, arising from Nakawa capital case number 8 of 2025 at Nakawa Chief Magistrate Court. Colonel, retired, Dr. Kiza Besigye. 2, Haj Obed Butale versus Uganda. Before Honorable Lady Justice Rosette Comfort Kania, ruling. The ruling is of 17 pages. Lead counsel, you want each and every word written on this ruling, or you want salient features? And for the one who has not yet, who did not get the chance of getting to UPE, yet is interested, we shall pronounce the whole of it, I think, for the benefit of the public. Background. Colonel retired Dr. Kiza Besigye and Haj Obed Butale, hereinafter referred to as the first applicant and second applicant, and where the context permits, the applicants. We are charged with 1, Section 223, Subsection 1, Part C of the Penal Code Act, Cap 128. 2, misprision of treason, contrary to Section 25 of the Penal Code Act, Cap 128. The prosecution alleges that the applicants and others still at large between the year 2003 and November 2024, while in various cities, including Geneva, Switzerland, Athens, Greece, Nairobi, Kenya, and Kampala, Uganda, contrived a plot, act, or matter by force of arms to overturn the government of Uganda, as by law established and expressed or declared such plot, act, or matter by utterances and overt acts. In the alternative, the prosecution alleged that the applicants and others still at large in the places and in the time frame aforementioned, knowing that another person intended to commit treason, did not report the same to the authorities or use all reasonable endeavors to prevent the commission of treason. Legal basis of this application. The applicant brought this application by notice of motion under Article 23, Clause 6 of the Constitution of the Republic of Uganda, 1995, Section 15 and 16 of the Trial on Indictments Act, Cap 25, and Rule 2 of the Judicature Criminal Procedure Applications Rules, for orders that A, the applicant be admitted to bail and released from remand / custody. The grounds of this application are stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that A, on the 21st day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrates Court of Nakawa at Nakawa and remanded in custody. B, the offenses with which the applicants are charged are only bailed by this honorable court. C, the applicants are responsible citizens of Uganda who have permanent places of abode as follows. First, applicant at Buyinja LC1, Wampeo Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukonjiri Municipality in Rukonjiri District. Second applicant at Kisigula Village Cell, Mutundwe Ward, Gombolola Sabagabo, Makinde Wakiso District for the second applicant. D, the applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for mention or trial as and when once released on bail. E, the antecedents of the applicants demonstrate this respect for the law and for any bail processes they have benefited from. The applicants have not been committed to High Court for trial and are willing to comply with all reasonable conditions set for their admittance to bail. J, the applicants are of advanced age and have substantial sureties who are willing to ensure compliance with bail conditions once applicants are released on bail. H, it is fair and just that the applicants be admitted to bail and released accordingly. At the hearing, the applicants were jointly represented by Honorable Elias Lukwago, Mr. Ernest Kalibala, Mr. Apollo Katumba, Mr. Wanda Samuel, Mr. Samuel Moyezi, Mr. Kunhira Proskovia, MS, beg your pardon, MS Kunhira Proskovia, Mr. Kato, Mr. Bayan Turinawe, Mr. Farouk Kamlegaya, Mr. Kintu Michael, Mr. Amanya Timothy, Mr. Kato Wilson, and MS Silas Oguru. The respondent was represented by Chief State Attorney Joseph Chomohendo and Chief State Attorney Richard Birivumbuka. Both the applicants and respondents made oral submissions at the hearing and filed written submissions for which this court is grateful. The said submissions have been considered where necessary. Submissions. It was submitted for the first and second applicants as follows. Article 23, 6A of the Constitution of the Republic of Uganda, as amended, spells out the right of an accused person to apply for bail and enables this court to grant bail on such conditions as it considers reasonable. Section 15 of the TIA, Cap 25, provides that this honorable court may at any stage of the proceedings release the accused person on bail. Pursuant to Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Constitutional Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel further cited the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. Once the exceptional circumstances are listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old, respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16th November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Tracy J. Charles versus Uganda, criminal application number 8 of 2011, counsel stated that the courts have recognized that prison conditions are not favorable to the health of old people, who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides for that the other factor that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants said that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious, grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. That in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24 of 2024, the International Crimes Division of the High Court, ICD, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application, and held that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provided that doing so does not compromise the interests of justice. It was further submitted for the applicants that the nature of the offenses with which the applicants are charged are political offenses, and that these two are not. And on that account alone, the kind of offenses in respect of which bail cannot be granted, that the first applicant particularly has been charged with various political offenses over the years, offenses in respect of which no conviction has been returned by the respondent. Counsel cited Makoha Samuel and 35 others versus Uganda, Supra. Counsel submitted that other conditions to be proved before court include antecedents of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panju versus R 1973 South African Law Reports at page 282, where the court held that allegations of interference with witnesses must be substantiated, and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in applications for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. In reply, counsel for the respondent submitted as follows. Section 15 of the TIA and Guideline 3 of the bail provides conditions that court should take into account in considering bail applications, including the substantiality of sureties, nature of the offenses, age of the applicant, possibility of interfering with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Guideline 15 of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties: the age, work, residence of the sureties, character and antecedents of the surety, relationship of the surety to the accused, stroke applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties, to wit, Honorable Semuju Nganda, a close friend, age 52 years. Honorable Francis Mujuche, a close friend, aged 41 years. Honorable Hindo Harold Tony, a close friend, aged 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, aged 50 years. And that the second applicant, produced by Najita Halima, the second applicant produced Najita Halima Lutale, a wife and aged 58 years. Namfuka Zuhura, a daughter aged 27 years. And Counsel Sewan Kambo Hamza, a friend aged 48 years. Counsel submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And in such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. Counsel cited the case of Mugera John versus Uganda, Criminal Administrative Application number 21 of 2025 at International Crimes Division, Honorable Lady Justice Alice Komuhanyi Kawuka held, it is my constant view that a surety should possess a certain amount of authority and or influence over the applicant. The sureties presented by the first applicant have no authority and or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from LC1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, counsel submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. The first applicant produced only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Counsel add that friends do not have the necessary leverage or influence to ensure the first applicant's compliance and are most likely unwilling to take steps to enforce compliance. Counsel cited the case of Tusime David versus Uganda Criminal Administration Application number 29 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Counsel said that if court was uncomfortable with raising the applicant basing on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to release the first applicant with just friends as sureties. In his submissions, counsel submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicants dispense this requirement. Counsel cited the case of Mugera John versus Uganda Administration Application number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Aliviza upheld the above view. It was further submitted that none of the sureties provide their work or business identity cards. What was annexed are passports and national IDs, which have no relationship with the business or employment or gainful income and disposable income, which are critical in assessing their substantiality. In Asimu Anna versus Uganda Criminal Administration Application number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability by the sureties, regardless of their position in society or government, is fatal and goes to the core in the grant of bail applications. Advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved, as was held in the case of Tumusime David versus Uganda Criminal Administration Application number 29 of 2019. The offenses with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Kano retired Dr. Kiza Besigye, Constitutional Reference number 20 of 2005, the Justice of the Constitutional Court held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offenses. The court must weigh the gravity of the offense and all other factors of the case against the likelihood of the applicant absconding. In the case of Foundation for Human Rights Initiative versus Attorney General, Supreme Court Constitutional Appeal number 3 of 2009, the Justice of the Supreme Court held, among other things, that this article imposes on court the duty to ensure that they do not only consider the rights of the accused person applying for bail, rather the court should the interests of society at large. The first applicant has another pending charge pending against him at Buganda Road Chief Magistrate Court, which is part hard. Section 15, subsection 4 of the TIA provides other pending charges as a consideration court should take into consideration in deciding whether or not to grant bail in an application of this nature. In the case of Honorable Alan Sewanyana Aloysius and Honorable Segirinya Mohammed versus Uganda, Masaka Criminal Application number 18 of 2021, Justice Lawrence Tweyanze, while dismissing the application for bail, held that in an early application granted the applicant's bail, Lady Justice Victoria Nakintu, based on the fact that they had no other charges pending against them, but at the time of determining the present application, they have charges of murder against them, in addition to those they were earlier charged with. It was therefore submitted for the respondent that the pending charges against the first applicant are a good ground to dismiss his application since he committed the current offenses while on bail via Buganda Road criminal case number 624 of 2023. In respect to the fixed place of abode, it was submitted for the first and second applicants that whereas the respondent contends that both applicants do not have fixed places of abode because they did not provide land titles or tenants agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both the first and second applicants provided evidence on oath by way of 2 affidavits and attached LC1 letters in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Buyinja LC1, Wampeo, Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Kisigula Village, Cell, Mutundwe Ward, Gombola Sabagabo, Makindye Wakiso District, also within the jurisdiction of this honorable. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Buganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent has not provided any evidence of the stage at which the case at Buganda Road is, or whether in fact the first applicant has been put on his defense or found guilty. That he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Buganda Road case cannot be used against him, as it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail.